Okay. So good morning, everybody. Thank you for joining us this morning. Join us today on this virtual session. Our goal today is to facilitate discussion on the risk of investing in cannabis industry and how our experts share some insight about the risks in this particular area and in this very fascinating space. Of course, all company investment comes with some amount of risk, and there's no assurance that an investor will receive a return on his or her investment. That being said, with the passage of regulations around the country allowing cultivation and the sale of medicinal and recreational cannabis, many investors have been attracted to invest in this growing industry. Over the last several years, contacts and clients have come to us to inquire about investing in the cannabis industry, and how on many occasions came to us asking about remedies after investment projects that did not pan out. Many of our clients who introduced these projects often attracted to the high rates of return being offered by the companies and by the founders, without fully understanding the risk involved with investing in the cannabis industry. We hope that the discussion today will shed some light in this regard. As we move forward this program, I encourage you to post any questions that you may have for us and for the speakers today on the chat box, on the chat function here in this Zoom. We'll do our best to answer questions and pose your questions to the speakers as we go along. I do want to do a quick introduction of our panel speakers today. You see on the screen with me here is Kresimir Perhada, who is a corporate and M&A attorney and the chair of Vahe Khojayan's cannabis practice. Kresimir is one of the leading cannabis deal attorneys in Los Angeles, and this practice includes representing cultivators, manufacturers, processors, and retailers, MSOs, private equity funds, and public companies. He has had a tremendous amount of experience working in this relatively new space and a growing area for the law. Vahe Khojayan is an experienced litigator whose practice focuses primarily in the area of bankruptcy law, business and civil litigation, and real estate law, both in the state and federal courts. Vahe's a partner in Vahe Khojayan's Los Angeles office, and Vahe will join us shortly. I'm Ian Liao, and I will be the moderator for today's panel discussion. I'm also a corporate attorney, and my practice focuses on cross-border transactions, including those involving investments, M&As, technology, transfer, financing, and other corporate transactions. I'll do my best to keep this flowing and keep this interesting today. Like I said, any questions you may have, please post it on the chat box, and we'll address them as we go along. So jumping into today's program, Kresimir will start off by giving us some background on cannabis investment. And after that, we'll go into a panel discussion about various different topics. So without further ado, take it away, Kresimir.
Thank you, Ian. So welcome everybody to this presentation. I want to start off by saying, the purpose of this is educational and informational. The following is not legal advice. So I want to start off with a story from a client I worked with about 4 years ago. The client came to us and said, we'd like to invest $1.5 million in this project in California. The client was out of state. Could you please do some due diligence for us? And we said, sure, that's not a problem. We're happy to do some diligence. And we started looking into this project. The project was supposed to be California-based, a series of dispensaries. The problem we had was very straightforward, and it's a warning to investors, current and future. There was nothing to diligence. For example, none of the principals that were supposed to be running this cannabis venture were actually living in California. There was no lease for a cannabis property. There was no ownership of a cannabis property. There was no license for any kind of cannabis activity. There was no really developed business plan. All there was a series of a list of cities that the potential sponsors of this investment were going to get into. And at the end of the day, it was easy for us to come back to the investor and say, really, we can't really help you because there's nothing to diligence. There's nothing there. There are no agreements with other companies. There's no lease. There's no license. There's not even an application to get a license for the city or state anywhere. So at the end of the day, we really can't help do any due diligence. So I say that by way of background because many investors don't really do enough diligence in this space. What is typical in this space is for folks to think about investing money in cultivation, so growing cannabis, or also on the dispensary side, so the retail sale to folks. And most of the time that investment takes the form of some sort of equity, so whether it's common stock in a corporation or membership units in an LLC. And as a result, the investor has some standing with respect to the assets of the company, but not that much. What's starting to become a little more common is investors lending money to cannabis companies and becoming secured parties by way of a loan agreement, security agreement, and UCC-1 filings. So that's certainly a better situation. But in terms of looking at the process, the investor hopefully will have a professional advisor who will do some kind of diligence on the principals, ideally a background check of the principals involved in the company, because that is very important going forward. Hopefully some investigation will be done into the license itself to make sure that something exists with the city and the state if you live in a dual licensure state, meaning you need a local city or county license as well as a state license. And then a couple of other important issues, the lease or ownership of the actual property where the cannabis activity is going to take place. And that's important because we want to make sure that that lease and the location makes sense given the activity, given the zoning that we have in effect in the local jurisdictions, and the overall business plan. And finally, I'd also like to throw in, we have the issue of insurance with respect to what insurance the company has or will plan to have. So in the areas of especially manufacturing and retail, things like product liability or premises injury, those are very important issues because if something big happens and there is litigation as a result, you want to make sure that there is some backstop besides just the assets of the company. So I think I'd like to end it there, just offering up a quick overview, and let's take us into the panel portion, Ian.
That's great. Thank you, Kresimir. That was very helpful information. So I think as we move into the panel discussion portion, I do want to again emphasize that please feel free to type any questions you have in the chat box, and I'll raise those with the panelists as we go along. So as we start this discussion, I want this to obviously be a dialogue with Kresimir and Vahe, but specifically I think following on what you just said, I think I wanted to sort of ask you, what are some of the unique aspects of investing in the cannabis space that you haven't already talked about in the background session just now, but just kind of like give the audience an idea, what's so special and what's different from investing in other type of industries.
Yeah, so a couple things stand out. For example, Section 280E makes the business of cannabis much harder than it would be otherwise. And what it does is basically it limits the availability of normal, ordinary business deductions that other businesses would be able to take. So in the case of a dispensary can really only deduct the cost of goods, the cannabis product itself. So everything else, essentially, to simplify, is not tax deductible. So essentially, the dispensary is paying income tax on things that really shouldn't be taxed on. So that makes the economics are much harder as a result of that. Secondarily, other than MSOs and publicly listed companies, we still don't have bank loans and traditional bank financing in the industry. So if the company starts to struggle and you've made an investment, it is all that much harder to find other people to come and provide that financing. Obviously, outside of cannabis, it's a wide open field in terms of alternative investment and lending platforms. So that is another factor. The complicated licensure schemes, the city and state do a licensure, create all kinds of complexities that investors who are not familiar with the space tend to overlook, meaning a lot of investors will just take the company's word for it that licenses are in place and that there are no problems. And until recently, another factor would be very poor insurance products. Many of the insurance products that were sold initially had either no product liability coverage or very limited product liability coverage. So the insurance that was being sold to companies was really weak and had a lot of holes, which creates a lot of risk for investors.
Great. As we're talking, today's discussion is really about the risk of investing in this particular industry. I do want to kind of sort of have you talk a little bit about what some things that investors can do if they're interested in investing in the cannabis business. What can they do to protect themselves before making an investment in this unique space?
Yeah. So. Hire some advisors if you don't have familiarity with the space. Make sure you have an attorney, a CPA who has experience in the space, and really do a deep dive into the things we already talked about, the status of the license, the lease. In fact, you probably even want to look at the lease and understand, is the landlord getting a percentage of sales? Because that could be an issue with respect to reporting that to the regulators. You want to look at the insurance status. You want to look at really the background of the principals running this. And you want to look at, of course, the financial projections, the financial results, and have those stress tested by somebody who has experience in the space. In other words, do those assumptions make sense, whether it's a build out of real estate or its costs for distribution or anything else. You want to make sure that the estimates are within the realm of reality, or could be cost of product, whatever else it is, because when things go badly, they can go badly very quickly. So it's really, I would say, the focus should be due diligence and getting some qualified advisors around you to look at what is happening and try to gather as much information to make an intelligent decision.
Yeah, I want to come back to this question about advisors in a little bit. Excuse me, but I do want to. There's a question that's been asked by the audience that in the loan structure, as you described, what kind of interest rate are typical, and how does an investor capture upsides?
So, is your question as to what is the interest rate that exists?
Yes. What interest rate are typical?
Well, it's hard to say. I mean, so for the MSOs and the public companies, they're able to get interest rates. I think I've seen as low as about 6 or 7%, on up to 8 or 9%. But I think you could easily double that for non-MSO, non-public companies. So the hard money lenders are more likely to be 12 to 15 or higher. And that's going to vary, of course, depending on your size, the risk, and your ability to find alternative options. But I would say it's close to double as a ballpark.
And the second part of that question was, how does an investor capture the upside? I assume that the audience is asking about, how does that impact sort of investor decision, and how that impact the investors looking at a deal like this, if these businesses are being funded at a 12%, interest loans.
Yeah. Well, sometimes it's not only the high interest rate, but perhaps it's warrants which make that capital even more expensive. Warrants to purchase shares or the equivalent in an LLC. So that capital becomes even more expensive. The thing is, there are not a lot of options. So, the reality is that the company is going to have to find the best possible loan out there. And if they're not one of these institutional type of companies, then it's going to be hard to find, and the interest rates are going to be very high. I don't think that by itself is anything bad. That's just a market reality. And I would say, in fact, if there was a small operator who said that they could get 6% interest on a loan, I would be very suspicious.
Thank you. Let's go back to the question about advisors. How can we find the right advisors, and how can right advisors help protect investors if they're looking at investing in the cannabis business?
Yeah, so I think it comes down to just people with experience who've dealt with enough companies that they can add value, whether that's on the CPA side or on the lawyer side. And in terms of adding value, I think, initially it's really in that due diligence process, asking the right questions, making the investor aware. What are some of the issues to look at? The license, the lease, the insurance, the background of the principals, things like that, the business plan, really working through that. Because the good news is that with the right team of advisors, the risk can be reduced greatly. The bad news is if things go wrong, and we'll get into this with Vahe shortly, it's really hard to get your money back. It's not easy for a variety of reasons to get your money back, and there aren't a lot of great remedies. So really, I would say advisors can really help you on the front end to try to avoid that big mistake going in, because once you're in it, it's not easy to get that money back.
And I assume that's not just like any other investment. You're not just hiring quote unquote business advisors who are familiar with the space, but you also talk about lawyers and accountants who can advise specifically on the regulations, that's applicable in the area, or how do you deal with the financing and all the accounting aspect of it, right?
Yeah, so so take in California. I mean, there's no I'll say there's no single lawyer that is going to know the regulations of the, call it 60 to 80 cities that have cannabis ordinances, and all are slightly different. So you don't have to worry about it that way, but the person has to have experience with licenses in a variety of cities. So besides a big city, so for example, Los Angeles or Oakland or San Francisco, as well as some smaller cities, things like Desert Hot Springs or things in Ventura County, Santa Barbara, and cultivation regions, Mendocino, various other areas. So some experience across the board with different license issuer entities, the local entities. And again, in some cases, they're not just cities, they're also counties where the population is not dense at all.
Okay, and staying with the topic of regulation, I have a couple of questions from the audience that I want to pose to you guys. Yep. The first one is hemp and cannabis growing licenses. Are there a difference between these two, and whether the difference in market value between these two?
Can you repeat the question, please?
Hemp and cannabis growing licenses, are they different, and what are the difference in value between these two licenses?
Yes, I mean, they're kind of completely different. I mean, cannabis is subject to the state Cannabis Act, essentially, and has its own very specific and detailed regulatory scheme. I mean, hemp is really now more of an agricultural product that is really regulated by the USDA and by the counties in California and in other states. So they're very, very different animals. Hemp is really now closer to almost any other agricultural product, as opposed to cannabis, which is really regulated much more like alcohol or tobacco, very strictly regulated with a very complicated regulatory scheme. So you cannot really compare the two.
So thank you, and I want to move on to sort of talking about a little bit about sort of the common mistakes that investor makes in terms of making investment in this space. But as we, to go into this particular topic, I do want to raise another question that was posed by our audience, is that, about source of funding, like how do we ensure that we're not taking quote unquote dirty money, and how do we ensure that, we're told that the money is clean or being clean, how do we ensure that's not not an issue, that the company that the investors invested in isn't sort of violating the regulations somehow?
Well, yeah, that's a tough one in terms of source of funds. I mean, obviously, as a company looking for investment, if you really need it, you're going to welcome all takers. Now, how do you scrub the illegal operators out of that? Diligence, really. That's the only real way. Is to ask more questions, is to have an investor questionnaire, is to try to, look into the source of funds. I mean, there's only so much you can do as a company in any industry that doesn't take too much time and money away from actually running the business. Because if you had to spend 20 hours investigating each investor and a lot of time of your attorneys or investigators or other people, it just wouldn't be practical. So some amount of diligence on the investors is mandatory. So that could be in the form of a questionnaire. That could be in the form of having your counsel ask for documentation. That could be in the form of looking at the banking relationship that the investor has had in the past, things like that. But that's a tough, complicated issue. There's no quick answer, I would say.
Are there other common mistakes that you would highlight for investors that they need to avoid or they need to be careful?
Yeah, so we touched upon the issue of, the global issue, which is once the deal goes bad, it's hard to get your money back. There are all kinds of pitfalls in that process. I would say, most investors don't realize, and Vahe and I have worked on this case from the other side, most investors don't understand that they cannot go after both cannabis goods and the cannabis license. So, and those, of course, are the most valuable assets, generally speaking, of the entity. So take, for example, a brand or manufacturer, and you've made an investment. Let's say you've lent money and you have a nice loan agreement, security agreement, and all that. Well, that's all good and fine, but at the end of the day, you cannot go, unless you, the lender, are a licensed entity yourself, you cannot go out and seize the cannabis goods, meaning the edibles or the flower or whatever the product is. You can't seize that and sell it. That is not allowed under California law. And I think most other states have similar regulations. And as a corollary, you as the lender in this case cannot go out and sell the license. It's not transferable that way. It's not just an asset that goes willy-nilly across people. It belongs to the entity. And so the process to get at that license is a much bigger one and much more complicated than just a matter of what we see sometimes, some sort of foreclosure sale or forced sale that's authorized by some kind of loan agreement or security agreement. That doesn't work that well in the cannabis space.
Good. Now that Vahe has joined us, and I do want to, as I said earlier, as in my introduction earlier, Vahe is an experienced litigator with us in our Los Angeles office. He's experienced with bankruptcy laws and business and commercial litigation. So I'm going to start with the question for you, Vahe, is going to be, I want both of you to sort of answer that, but let's go with Vahe first. What happens when things go wrong with investment in the cannabis industry? talk about what are some of the things that you've seen and sort of your experience in terms of helping clients in this space.
Yes, so thank you for having me. It's a pleasure to be here. Good morning, everyone. I think Kresimir pointed it out that when it does go bad, it is difficult to collect. One upside that the investors have is, obviously most of the investment agreements, if their investors are represented by competent counsel, provide some sort of redress to them to do this. And most of the time, these agreements provide for some self-help options, foreclosure options, being able to go and seize the products and things like that. Again, we'll run into the problems that Kresimir just pointed out, that if you're an unlicensed person or entity as an investor, you cannot touch the cannabis products or sell them or liquidate them to recoup your investment. So you're kind of limited to non-cannabis related equipment, machinery, things like that, if there's any real assets and all those things. So that really limits your ability to go and do regular collections or regular foreclosures, as you would do, for example, in a car loan or regular equipment loan situations. There are ways, though, to do that. You can possibly apply to the court to appoint a receiver who most likely needs to be a cannabis licensed receiver who will be able to handle these products and through the court process liquidate those. And at that point, it's not you, the investor, who's liquidating and doing things, but it's the receiver who's a licensed entity who was appointed by a court order who's selling and liquidating these cannabis assets. So that's one way to go around. Most certainly, it's more expensive and more time consuming than simple foreclosures on the cannabis related assets, but at the very least, it's a legal way to handle it, and you will withstand challenges by your debtor, by the person that you lent money to, who might argue that you don't have a right to go and foreclose. Another upside for you is that there might debtors or people who borrowed money from you are not allowed really to be in bankruptcy and reorganize and waive your debts in bankruptcy. So that gives you a little more leeway to negotiate. But most likely, and the short answer to your question is, if things go bad, you're very, very likely to end up in court, spend a certain amount of funds and resources to be able to recoup your funds, assuming it's there. And that brings me back to have somebody like Kresimir on the at the beginning of the transaction to make sure that your loan documents, your recourses, and your documents are drafted properly, and they do provide for proper recourses and possibly third-party guarantees and things like that, that you may be able to recoup your money from third parties, not just the cannabis debtor that you have.
Kresimir, do you have anything to add on this particular topic?
Well, I was going to go back to some of the common scenarios because I think it's useful for people thinking about investing in the space. So there's an infinite number, but the scenarios that come to mind are these. So first one is, the company just runs out of money, good faith, nobody did anything wrong, and it just runs out of money, right? It overbought on inventory and undersold to the next person in the chain. So that happens. That happens in any business. Another is they get in trouble with regulators. And this happens from a variety of reasons. It could be a neighbor that's complaining about smells. I saw a question about wine country. I think in wine country, it's the issue there is contamination or smells, contamination perhaps by products being sprayed. I think those are some of the concerns. So competitors, neighbors, that's clearly an issue. And then also you have situations that has come up in California and other states where the company is doing everything right on the one end, but it's struggling so much that it's actually diverting product into the illicit market. And then something happens, law enforcement gets involved and it shuts down the entire enterprise. So those are some of the scenarios. Oh, and I should add the last one, internal conflict, right? The management or key shareholder or shareholders have a big disagreement and there's a deadlock on where to go, what direction to take, especially if the company is struggling. So those are some common scenarios that come up, and just things to be aware of, because if you're making an investment, those are things to be looking out for. Are there any indications of disputes? Are there any indications of problems with regulators? Any indications that the neighbors are complaining? Of course, that's hard to know if it's a relatively short time frame, but that's the whole point of the diligence process.
Okay. I want to dive in a little bit more about, so what happens when things go wrong, and God forbid all these scenarios that you guys presented happens, and based on the context, based on the questions that we received from clients over the last few years, that's not unusual that they come up against problems in this particular industry. But before I dive into that on what can they do, a couple of questions that's posed by the audience. And this is going back, this one's going back to the question about advisors. So other than lawyers and accountants, what are the technical advisors, would you recommend that they get if, particularly in a state where cannabis is only recently legalized, to provide technical assistance?
Okay, so attorneys and accountants are given, people who work with license applications, so consultants who have a lot of experience in that. If it's any kind of technical manufacturing expertise, consultants in that space, so the right kind of equipment, because it's become very, very specialized now. You can actually get a lot of equipment that's specifically made for the industry. So those would be things that come to mind. Experienced real estate brokers who understand the zoning in a particular city or location. Those are very helpful. So that would be my list just off the top of my head.
And the second question is it better for a company to be a C Corp, LLC, or sole proprietorship?
Well, that gets into some complicated structuring questions, actually, but I'll say as a general rule, licenses should be held, one license should be held in one entity, whatever that entity is, and in general terms, corporations tend to provide greater protection for investors than LLCs and partnerships, and that's like a rabbit hole of why, but that tends to be the case.
Great. Again, I appreciate the question from the audience, and please continue to do so on the chat box. So going back to our discussion about what happens when things go wrong. What are the remedies available to investors when things do go wrong? I know Vahe talked about it a little bit, but I will start with you again, Vahe. Talk a little bit about what happens when what remedies are available to investors when things go bad.
So one situation that we have been seeing in the past decade and a half already, I think since we've had legal cannabis in California, is a lot of debtors that end up in trouble, not being able to repay the money, try to use the bankruptcy system to go in, stop the collection efforts, and try to sort of reorganize their debt to their investors. One good news for the investors, and obviously bad news for the entity who's going into the bankruptcy, is that marijuana is still a Schedule I drug on the federal level. Yes, it's legal in a lot of states, but the federal government doesn't recognize it as a legal product. It's still highly regulated, it's still illegal. So bankruptcy system itself, being a federal court system, will not allow any transactions or anything under its umbrella, under its authority that relates to cannabis business. Most of the cases that we see of debtors trying to go into bankruptcy to stop creditor collection, creditor actions, end up being dismissed and kicked out of the bankruptcy system for that exact reason. And this isn't just in states with illegal marijuana. This is California, Colorado, Nevada, all of the states that are being in a bankruptcy is getting kicked out, especially if their revenue or a part of it comes from bankruptcy operation. There was one case where a landlord who partially derived some money from a bankruptcy tenant was allowed to continue, was allowed to proceed, but that's an exception and not the rule. Generally, you have bankruptcy asset, and cannabis asset, marijuana asset, you cannot be bankruptcy. Now that gives an opening to the creditor who lent the money to move in the debtor's bankruptcy case to dismiss that case and put the debtor out of bankruptcy. Bankruptcy generally is a power tool for the person who owes you money because it stops any collection that you may have. It stops any lawsuit that you have against the person to recover your funds. So that halts everything. But once you move to get them out of the bankruptcy, they're back as if nothing happened. They have your state court remedies in that case. And again, you may have some self-help options, but you're limited to non-cannabis assets. Yes, you can go and foreclose on the machinery, go take over the leases if that's allowed, maybe some chattels or something like that. Real property assets, by all means, go ahead. But when it comes to foreclosing and taking over cannabis assets, you're precluded from doing it yourself. Again, you have to go to California state courts in this case, who recognize the legality of the cannabis, but also recognize that it's very regulated. And the state courts will have to function through receivership procedures to appoint a third party to be able to liquidate, maybe run the business, maybe take the incomes out and get you paid. And again, the alternative, the third party alternative is if the creditor at the time was able to obtain some personal guarantees from the owners, some sort of security agreements from the third parties, non-cannabis businesses, maybe the investment company, the holding company that is owned by the same people, then that gives you another opening to go and enforce your guarantee because you're not getting paid. There are avenues, it's a minefield. You have to navigate very, very carefully. Important to have competent counsel, important to know what you can and cannot do, because yes, you might be able to recover some more money if you skirted the law a little bit, but that gets you in trouble and basically is not worth it at the end of the day.
Yeah, I would follow up on what Vahe is saying. I mean, it seems to me, and this is theoretical because a lot of times this is not a practical option, but seems to me having a personal guarantee on top of whatever loan agreement and security agreement you have is one option, because then it takes it out of a problematic context of the regulatory system and everything else. Of course, that depends on the financial status of a person or entity that's providing the guarantee. So if things go really badly, there's a decent chance that your guarantor is in bad shape as well. But as a theoretical option, it is very attractive because theoretically, the issues you have with going after the assets of the business are really eliminated when you have a guarantor, and it's just a clear situation that you can take through arbitration or litigation.
I do want to revisit, and this, you may have addressed this a little bit, but I kind of wanted to sort of have you guys sort of talk a little bit about, is it possible to get security interest on the equipment for investors? You know, in terms of, you talk about personal guarantee, but in terms of, together with the guarantee, can they get a security interest on the equipment, for example?
Oh yes, absolutely. Equipment's not considered a cannabis asset. I mean, if it's manufacturing equipment that manufactures things, packages things, of course. And ordinarily, your security will extend to those assets, and you will be able to realize and foreclose or sell these assets to recoup some portion of the equipment. Again, you have to be very careful, make sure that your security interest is perfected, your UCC recordings are done, if there's any county recording requirements for real estate or fixture type assets, those are done, because improper recordings and then a step in foreclosure may waive your right to recover the balance of your investments from the remaining parties. But if everything's done properly, nothing precludes you. I don't want to say nothing. If your contractual language is appropriate, then you may very well just move forward and foreclose on equipment, non-cannabis inventory, non-cannabis related assets, and recoup a portion of the investment. Absolutely, yes.
And is that a separate and different procedure than what you talked about, right? Because if you're foreclosing on if you're trying to close on the cannabis business, you said you got to go through go through the courts and the receivership process. Is that this, do they deal with the whole, whole thing?
Yeah, and so just going and foreclosing on the equipment itself, if you have appropriate legal agreements, the California Commercial Code allows you to do that without any receivership, without any court intervention, as long as your documents provide the language for it. That doesn't mean you can't do it as part of your receivership process in court if you go do that. But yes, these are the two separate processes that we're talking about. I mean, receiver, after all, is just a third person appointed by the court to take over the business and get as much money as possible from the business. And of course, cannabis licensed receiver will be able to do a lot more than non-cannabis licensed receiver, who is again only precluded from taking cannabis assets and may only foreclose on non-cannabis equipment. So it becomes kind of pointless because you can do that out of court anyway.
And I'm assuming I'm sorry, go ahead.
Yeah, what I would say is, apart from the legal aspects of this, it becomes a little bit of a math problem, right? If for example, you've as the investor or lender have lent $1 million to a company, if they have equipment worth $200,000, even if you're the only secured party, that's not going to help you very much, right? So it really becomes an issue of how much are you lending? How much are you investing? Are there other secured lenders out there? How much do they have in assets that are subject to a foreclosure sale? So it's very fact intensive, right? As to the utility of going after those things. In a lot of cases, I'll tell you what I see is the equipment is not nearly enough. It's something, but it's not nearly enough to recoup the investment or the full investment that the investor made.
Okay, but so I came across a situation of a contact, and I think this is, it's one of those situations, as you said, right? The company just ran out of money. Their equipment is sitting in the warehouse in their plant or whatever, and the founder basically said, "Here are the equipment. If you want to come and get it, feel free." But I'm assuming it's like anything else, like a regular type of foreclosure or any type of these kind of dispute. That if one investor come and take some equipment out of the warehouse, it is subject to clawback if there's a foreclosure proceeding by the court. Is that correct?
I don't.
Assuming there's not a security interest. I'm assuming there's no security interest on the equipment.
Yeah, if you have the security interest on the equipment and you can do two things. You can come take over and sell it at an auction, and then the new buyer just buys it and you have the money and you move forward. Again, I want to stress that you have to have the provisions allowing to foreclose on the security, on the equipment in your agreement, because the California Commercial Code approved language has to be in there. Once you foreclose, you sell it at an auction, you take the money and you credit the remaining balance. Well, that's it. I don't think there's any clawbacks from the third parties who came and bought the assets from that. If you took the assets and you bought it at the foreclosure sale, then there may be some situations where you're open to challenges about Friday of foreclosure, whether everything was procedurally right or not right, and especially you as a lender are the buyer at the sale. So you may be open to some challenges. If everything's done properly, likely not to succeed these things. And again, it's not like they can come and take the equipment and everything back without paying the money or anything for it. There has to be some sort of a compensation for those. But again, if the sale is at an auction, third parties buying it, investors pretty much realizing the proportion of the investment coming back to it, it's more likely than not to be upheld and to be a valid sale. Yes.
Well, I was asking in the case where there's no security interest. For example, the three of us are investors. I come in and I take a bunch of equipment without you guys knowing, and then you guys pursue a claim against the company. I'm assuming whatever I take out of the warehouse is going to get clawed back by the court.
Oh, yeah, without a security agreement, that becomes problematic because again, as an investor standing right in there as an unsecured, you lent money, you don't have anything saying you have right to the security interest. You're pretty much like taking their stuff without permission. It's not really a legal way to try to recoup any portion of the investment. Then I would think that the debtor will be very upset and will try to get that done. Could be remedied by an agreement between you and the debtor saying, well, how about you take this equipment and deduct a portion of the fund sale? But that's the easy way out. Usually that's not how it works, I would say. But yeah, that's problematic. I agree.
Right, because I think that's kind of the typical situation, you know, the founders or buddies says, just take this and settle my debt, you know, and then there's other investor who says, you know, hey, that's a problem for me because you're taking assets, and that's what I was asking about, is being called back.
Right, and you're right. Now go back to Kresimir point about that, because again, if that's the case, you're doing that agreement, you're basically doing some court satisfaction type of agreement saying, take this, deduct this much, or satisfy the debt. You have to make sure that that equipment you're taking is not subject to other secured interests by other parties, because if you are taking those, you're taking them subject to those liens that the other parties have. So it's important to do your due diligence and make sure at least you have a lawyer or an accountant or somebody who can make sure to search the liens and find out if you're taking the assets free here or not.
So what about, so I mean, and I think this is kind of what I'm asking, you know, can we do, what about assignment for the benefit of creditors in cannabis? Can we just assign things to the creditor?
Possible. Again, Kresimir maybe will supplement me after this. It's possible to do that. Again, there's two ways to do it. If you're assigning, and this assignment of the assets or assignment of the receivables and things like that are cannabis related or cannabis derived products or monies, it's very murky. The legality of it is questionable. If you're assigning your non-cannabis assets, your existing things, giving them security interests and things like that, that may very well work. Again, you have to make sure that you're not crossing the line of, you know, here, take my receivables from this dispensary that owes me money and have him pay you. It may, even if the debtor or the entity consents to it, again, you're receiving as an investor, as an unlicensed cannabis investor, unlicensed cannabis party, cannabis-related funds and interests. So that may be problematic from a regulatory standpoint. If it's, again, open to interpretation most of the time, but I would be very careful in doing any sort of assignment without proper legal advice.
Well, in the problem I've seen actually happen when companies have tried this is, I mean, it sounds great from the company's perspective and perhaps even an investor perspective, but the problem is you can't force all of the creditors into the process. And so let's say you come up with a solution. The problem is then you have someone else hanging out there, and they can then sue you, the investor, and the company for basically, you know, taking what should have been shared with them. So it can get extremely messy as a result, as opposed to receivership is, in theory, a little more likely to be cleaner and neater with all the creditors in the process.
Yeah, and one last thing I want to add to that is, usually when a company has more than one creditor or one class of creditors and there is assignment made for the benefit of one, that will, in majority of the time, trigger a default clause in any other lending or creditor agreements that they have. So that will immediately wake up all the other creditors to come and start exercising their interests. So that will just add to the mess that the company will create for itself by doing the assignment for the benefit.
So it sounds to me like the best approach in this context where the business is going under is for that to go through this process and have the company go into receivership so that the receiver can then, you know, like you said, run the business, but also, you know, go through all the debt, including the investors who are for the most part unsecured creditors, to sort of allocate the resources, allocate the assets, allocate the receivables, and sort of on a fair basis. Is that an accurate summation of what we just talked about?
I would generally agree with that, given the fact that bankruptcy is not really an option. Self-help limits your remedies and your collection amounts from your general investment. And again, as one creditor, you may not know who else is out there because that's information with the company executives who hold that. And the receiver coming in and taking over the company will be privy, will know what's happening, who's out there, who's getting paid, who's priority, and sort of clean up and do an orderly repayment or liquidation, whichever is chosen.
And other than this approach, have you guys seen any approaches to resolving these kind of situations that are successful? And that's for both of you to answer. Other than going through receivership.
Well, I guess I only deal with situations when there, resolution attempts have failed. Maybe Kresimir has had more experience with those.
Well, so in the case where there's an internal conflict, just negotiated settlements. I've seen that work. I've heard of receivership situations that have worked out where there were good receivers in place that did the right thing and actually, created new life in this business that came back after a crisis. But even receiverships often can go bad with the wrong receiver. I mean, we've just come across a case that's currently in the courts in San Diego where the receiver did the wrong thing. The receiver essentially had an auction for the business, and instead of taking the highest bidder, took the lowest bidder, and the bidder who didn't provide source of funds, and now there's a protracted battle over that issue. So even in the receivership situation, which in theory is one of the best options, things can go off the rails quickly if the receiver or whoever's running the business is not really doing the right thing or is some way acting improperly. You get into all kinds of problems. In this case, more litigation likely as a result of these missteps.
Thank you. And I have a few more questions from the audience that I want to sort of combine some of those, and I want to ask you guys. And I think this is a pretty interesting question. You guys talked about not being able to sort of take in cannabis assets and deal with it in bankruptcy space, but is it possible to sort of take cannabis business and cannabis assets in a capital raising process? In other words, I don't know if you guys heard of companies that gone public with cannabis business, whether by way of a public offering or some sort of SPAC or some sort of financial transaction. And related to that is in terms of investment by venture capital and private equity players in this space, and how that plays into the whether there are any obstacles for them to do that, or any issue. Are you seeing examples where VCs and PE invested in cannabis business?
So with respect to public listings, they tend to take place in Canada because there you have federal and provincial legality, so there are no issues at all. In the US, the exchanges are much more restrictive, we'll say, limiting listings to things that are either ancillary or legal in the state of origin or country of origin, such as Canada. So it's much more restrictive until we have really federal legalization. You're not going to see the kind of traditional IPO you would expect in the space, a plant touching business that's US only and has no other sort of excuse would traditionally not be able to list in the US, but certainly in Canada and in other places. In terms of private equity, yes, there is private equity investment. Some of that has been going on for a couple of years, but it's pretty limited. Some of that has turned into investments through SPACs recently. And there are no specific rules other than the listing issues that we came across and the federal illegality aspect.
And I think related to that question, being the fact that it's, as you say, it's federal legality question, has there been an issue with finding, financial services for cannabis business or any other services, escrow services and title services? Are there any issues with them obtaining these kind of services for cannabis business?
Absolutely, there are issues at almost every level. I mean, there are issues at the banking level, finding a bank that will bank a plant-touching cannabis company, finding insurance products, insurance companies that provide coverage, dealing with lenders on the landlord side or property owner side that don't have a illegality clause, right, in the mortgage or in the loan agreement that would prevent them from renting out space to a cannabis company. So at every level, escrow services, absolutely. Escrow companies in general will not hold any kind of cannabis securities or cannabis cash or cannabis anything. So in situations where you have M&A transactions and you need an escrow, it can be extremely challenging.
So even we're talking about, for example, insurance on the property that grows, that's used for cultivation, that you may not be able to get property insurance for that particular.
Well, yeah, I mean, obviously there's cultivation in quite a few places in Northern California, in the Emerald Triangle, in Santa Barbara and Ventura counties, in the desert communities. So it exists. It's just not easy and commonplace. It's getting better, but it takes some work to get there, just like finding a bank that will bank you.
So I'm going to deviate a little bit from what we're talking about things going wrong, but going back to this process about investing in this space. As an investor, as counsel to an investor, who's usually taking the lead in these kind of investments? Is it investors counsel, or is it a company counsel who would then take the lead in this discussion and taking the lead in terms of documenting everything?
Well, it really should be investors counsel, because the investor really has all the risk on their side. So really it makes sense for that side to think about how the investment is going to be made, equity or debt, what documents can be created, what diligence needs to be done. And then, thinking about just some of the things we talked about, how much equipment is there that could be potentially sold if something goes wrong? What are the other assets? So walking through that, there really should be squarely on investors counsel.
Okay. And I think it's probably a good idea for the counsel or the investor to actually go out to the property where it's being cultivated or it's being sold to make sure that it's actually there, huh?
Well, someone should. Yeah, exactly. That's part of the diligence process. I mean, one of the things that comes up is people ask if they can do business with a certain cannabis, I'll say cannabis business in a certain city or county. And it's very easy to verify. I mean, all you have to do is see if there's a cannabis ordinance in that city or county that allows any cannabis activity. And if there's no ordinance, well, guess what? No cannabis activity is allowed. There doesn't have to be a prohibition. In fact, it works the opposite. There has to be a cannabis ordinance that allows cannabis in the city or county. Otherwise, you can assume it's illegal.
Right. And then to add to that point, Ian, I've had clients who were induced into investing in startup cannabis businesses, we're getting licenses, we're in a process and things like that, investing hundreds of thousands of dollars, sadly on an unsecured basis again. And then ending up, the business never started, it never picked up, they're lending to an LLC or a corporation that has not been formed. So they basically end up just holding the bag for the money that they gave to a guy who never really took off the ground and who knows used the money for what. These situations arise. So it's important for someone to actually go see that there is a valid operation. Because otherwise you're just a collector trying to collect your money from a person who may or may not have any assets. So.
Well, I look at it looks like our time has come to an end today for our session. And I do want to, I do have another question before we close, but are there any major leasing companies that specialize in cannabis equipment?
There are, I don't know of any names off the top of my head, but yes, there are some out there, yeah. Especially when it comes to things like extraction and other categories, yes. Yes, there are.
Is it, I mean, I guess the question is these equipments, because are they specialized to cannabis? Otherwise, would they be, subject to this whole idea that you can't finance the cannabis business? Because it's financing. It's project financing.
I don't think so. I mean, they're certainly not going to be applying to the city and state for licenses. They are providing obviously the equipment that makes some of this happen, but they don't have any control of a cannabis product or cannabis good at any time, right? They're just installing equipment. Those folks are not going to be licensed unless they have their own cannabis operation. And maybe they have a leasing division, okay, but otherwise they're not going to be licensed entities.
Well, like I said, we're coming to the end of our session today. I do want to encourage everybody to reach out to us. If you haven't had a chance to ask a question today, to send us an email, and we'll be happy to answer your questions, directly and individually. Send it to myself, Vahe, or Kresimir. We're happy to answer your questions if we didn't get to do it today. Again, thank you for your attendance. But before we end, I do want to give Vahe and Kresimir a chance to just kind of do a quick closing comment before we go.
Yes, it's important. Hire a lawyer at the very beginning. Don't wait till it goes bad to start consulting legal counsel. The amount of money that you spend at the outset, at the beginning of your investment, at the beginning of your organization, your process is well worth and is dwarfed by the amount of money you will spend on litigation if documents are not drafted properly or your remedies are not outlined properly. So definitely consult an attorney. If there is one takeaway from this meeting, from this webinar that you have, it's very important to have competent professional advice before you jump into the industry.
Yeah, and I would say, while the industry appears to be extremely sexy and lucrative and a ton of money being made, it's incredibly complicated and full of, many of the potholes that we talked about and hurdles. So while yes, people have done well, especially now with the tax regulations and all the taxes and fees these companies have to pay, it's not nearly as profitable as people think it is. And that affects and should affect how you think about investments, and is why you really need to think about creating a team of advisors before you commit any serious capital to a cannabis venture.
Thank you both. And again, thank you everybody for attending this session. We look forward to having an opportunity to discuss this with you guys further in person or online through email. Please reach out to us and thank you.
Thank you, everyone.
Thank you.